Jai Hind to all of you. I am Updesh Kumar Jaiswal, working as an assistant professor in Department of CSC, Ajay Kumar Garg Engineering College, Ghaziabad. Today, I am going to deliver a lecture on intellectual property rights and law. This is the topic of the subject Constitution of India, Law and Engineering. The subject code is KNC 501. The outline of my today lecture is meaning of intellectual property, types of intellectual property rights, that is the IPRs, industrial property like patent, trademarks, geographical indications, industrial designs, trade secrets, and then copyright, and finally the references which I have used to deliver this lecture, to make this lecture. Firstly, I want to discuss what is the difference between the invention and discovery. An invention is a new product or process that solves a technical problem. But discovery, which is something that already existed but had not been found till date. Intellectual property, property created by application of human mind. It is intangible in nature, that is non-physical, derives values from ideas. The definition of intellectual property is intellectual property refers to creation of the mind such as invention, literary and artistic works, design and symbols, names, images used in commerce. Legal rights which results from intellectual activity in industrial, scientific, literacy and artistic fields. Intellectual property. There are two categories of the intellectual property, that is the industrial property and copyright. In the industrial property, patent, trademarks, geographical indication, industrial designs, trade secrets come. Whereas in copyright, it is the second category. Nature of intellectual property rights. Essentially, negative rights stop others from copying or counterfeiting. Statutory rights, legally enforceable, limiting period of monopoly with obligation to disclosure except trade secret, territorial in nature. These are the different natures of intellectual property rights. Why IP protection? Why intellectual property rights should be protected? What are the benefits of protection? Capital expenditure for new product, research and development, marketing and advertisement, maintaining loyal followers, and finally the profit. Due to these reasons, intellectual property rights should be protected from the others. Intellectual property, that is the IP, is the property that can be sold, can be bought, can be leased or rent, can pass under a will, can be assigned. So, firstly, I want to discuss about the patent. It is a form of monopoly for a limited period of time intended to encourage disclosure of useful inventions. It excludes any other person from manufacturing, using or selling. A type of social contract between the inventor and the state. We can say patent is a contract between the inventor who is inventing the product and the state, that is the government. It is an initiative to innovation. What is patentable? What are the things which can be patent? Invention in all fields of technology, whether products or processes, if they meet the criteria of being patentable subject matter and have novelty, non-obviousness, that is the inventive step, industrial application, that is the utility. So we can say there are three conditions for patentability. First is the novelty, second is inventive step, and third is the industrial application. I will discuss each one by one. Novelty, invention not known to public prior to claim by the inventor. Inventive step, that is the second condition. Invention would not be obvious to a person with ordinary skill in the art. Industrial application, invention can be made or used in any useful practical activity as distinct from purely intellectual. One. So these are the three conditions which are required to patent a product. So what should be the structure of the patent? How patent file will be created? So we can say patent specification. A patent specification should have following headings: abstract, field of the invention, background of the invention, summary of the invention, brief description of the drawings, detailed description of the preferred embodiment, claims and drawings. These are the different headings which are required to make the patent specification. After filing the patent is published, and I am showing here one of the example of the patent which is published, and date of filing this patent is 10th of November 2022. Applicant name is given, title of the invention, field of the invention, and publication date, that is the 25th November 2021. And application number is very important. And this picture is taken from the Intellectual Property India. This is the Form 5, the patent according to Patent Act 1970. Here the name of patentee is given and different members. Name of the applicant is also showing here. In another example, it is showing the United States patent. We can take the patent in India and all over the world also. In this, inventor, assignee, notice, application number, field, everything is written. There are some things, some products, some process which are excluded from the patentability. It means they cannot be patented. Patent cannot be taken for that products. Naturally occurring substances or elements, we cannot take the patent of these things. Diagnostic, therapeutic, and surgical methods of treatment of humans or animals, plants and animals other than microbes. Essentially, biological processes for production of plants or animals. Invention whose use is opposed to public order or morality. Patent rights. First right is regional, second is patent cooperation deal, and to take the patent all over the world, WIPO, World Intellectual Property Office is working. Suppose I am taking the patent in a state, then it will be regional office. We should apply for the regional. Patent cooperation deal, it covers all over India, and to go outside the India, World Intellectual Property Office work. And the validity of patent is 20 years. It is very important to note down. Now, trademark. Here, different trademarks are represented, like trademark of Mercedes, trademark of Coca-Cola, Nokia, Sony, Microsoft, Apple, Nike, These are the different trademarks. Trademarks are also called as the TM in the short. These are the different trademarks I am showing here. Taken as example. Trademark, service mark, and trade name. Distinguish symbols, signs, logos that help consumer to distinguish between competing goods or services. A trade name is the name of an enterprise which individualizes the enterprise in consumer's mind. Legally not linked to quality, but linked in consumer mind to quality expectation. It is not directly linked to quality, but it presents the quality in the consumer mind that the product will be of the good quality. In case of visual things like words, letters, numerals, device including drawings and symbols, 2D representation of object or a combination of two or more of these, color combination, 3D sign as shape of good or packaging, audio like sounds, music, notes. We can take the trademark of these things. Validity of trademark 10 years. It is renewable. After 10 years we can renew. Should not be straightforward. Distinguish is the key. Indian Trademark Act 1999 is working, and we should firstly file the application to get the trademark, then registration will be due. And according to Indian Trademark Act 1999, if anybody is copying, then opposition can be done by the law and rule. Next, geographical indication. In short, this is called as the GI. In this diagram, I am showing different geographical indication used like Darjeeling tea, Banarsi sari, and Jardin Champagne, etc. Indian geographical indication like Darjeeling tea, Basmati rice, Bikaneri bhujia, Banarsi sari, Kanchipuram silk sari, Nagpur oranges, Kolhapuri chappals, etc. International geographical indication, I am showing here Washington apples, Florida oranges, Jardin champagne, etc. What is geographical indication? GI. Many goods possess their peculiar, that is called as a special property due to their geographical origin. Geographical indication is the best method to indicate the geographical origin of goods and services. Many agricultural products like tea, rice, dairy products, cheese, wines, and spirit owe their special quality and reputation to their geographical place of growth of processing. Protection of GI. GI is not owned by a single owner. It is very important to know. Geographical indication is not only owned by a single owner. Any producer in the region can use the GI on the product provided it is prepared by the norms set out for the use of that geographical indicator. GI is the register in the national register. It should be mentioned, it should be registered in the national register and is similar to the certification mark identifying the origin of the good. Government can register GI in the international register for worldwide protection. To provide the worldwide protection, government will register it in the international register. It is an offense to use false GI on goods. If I am using the false GI on any product, then it will be a crime. I will be a culprit. Next, industrial design. These are the different diagrams which are showing the industrial design, which are particular and specific The aesthetic aspect of an article that enhance visual appeal and differentiate product is shown by the industrial design. Example, 3D features of shape or surface as of a perfume bottle, 2D patterns of line, shapes and colors as on the bedsheet. They are reasonably accessible to small and medium-sized enterprises, to individual artists and craft makers, and where industrial design is applicable. Industrial design are applied to a wide variety of products of industry and handicraft items, from packages and containers to furnishing and household goods, from lighting equipment to jewelry, and from electronic devices to textile. Industrial design may also be relevant to graphic symbols, graphical user interface, and logos. Criteria for protection as industrial design. It should be new and original, capable of mass production or application on an article of utility, not against to public order or morality. Now I am here comparing between the industrial design and trademark. In case of industrial design ID, it has to be integral part of the product, whereas in the trademark it is applied on the product but need not be embedded in it. Second point, ID should be original and new but need not be different. It should be distinctive, it should be different. These are the two basic difference between the ID and TM. Next, trade secret. Coca-Cola is using the trade secret. Coca-Cola remains a leader in the world soft drink industry based on its trade secret formula over 100 years. Trade secrets are protected by state law, government law, and may consist of any formula, pattern, physical device, idea, process, compilation of information that provides the owner of the information with a competitive advantage in the marketplace, and is treated in a way that can reasonably be expected to prevent the public or competitors from learning about it. Here I am showing the different intellectual property laws of India and the department who is working on this or who is involved in this. Copyright Act 1957. In India, it is handled by the Department of Higher Education. Patent Act 1970. It is handled by the Department of Industrial Policy and Promotion of the government. Design Act 2000. It comes under the Department of Industrial Policy and Promotion. Trademarks Act 1999. So Trademarks Act was developed in 1999, and the department which are handling Trademarks Act are related to trademark things application, that is the Industrial Policy and Promotion Department. Geographical Indication of Goods, Registration and Protection Act 1999. It is also dealt by the Industrial Policy and Promotion Department of the Government of India. Semiconductor Integrated Circuit Layout Design Act 2000. It is handled by the Information Technology Division or Department of the Central Government of the India. Protection of Plant Varieties and Farmers' Rights Act 2001. This is handled by the Agriculture and Cooperation Department of the Indian Government. Competition Act. This is handled by the Corporate Affairs. Biological Diversity Act 2002. Environment and Forest Department is handling this thing in India. Now, copyright. Here I am showing the different goods, services for which I can take the copyright. Copyright is represented by this symbol. Copyright is used in literary work, musical work, artistic work. Copyright laws grant authors, artists, and other creators protection for their literary and artistic creation. The word author is important here. A closely associated field is related rights or rights related to copyright that encompass rights similar to or identical to those of copyright. The beneficiaries of copyright are performers such as actors and musicians in their performances, producer of phonograms, for example compact discs in their sound recording, and broadcasting organization in their radio and television programs. These are showing this diagram. So who are benefited? I am mentioning here. I have mentioned here. A closely associated field is related rights or rights related to copyright that encompass rights similar or identical to those of copyright. Basics of a copyright. It should be original, tangible, need not be new. Copyright owner has the right to be prohibited. Its reproduction in all forms including print form and sound recording, its public performance and communication to the public, its broadcasting, its translation into other languages, its adoption such as from a novel to screenplay for a film. So these are the rights that can be prohibited if I am taking the copyright of any product. Rights covered under copyright. Two kinds of rights are covered in the copyright. First is moral right and second one is the economic right. In case of moral right, protect personality of author. In case of economic rights, bring economic benefits. These rights can be transferred, assigned, licensed for economic benefits. These are very important things. Is it necessary to register a work to claim copyright? Many people are confused and they are asking this question. Is it necessary to register a work to claim copyright? So answer will be, this is automatic right created with the creation of work and no registration is required. Use this symbol for copyright. I already told this symbol is used in case of copyright. Who is an author in case of copyright? In the case of literary or dramatic work, the author will be the person who creates the work. In the case of musical work, the composer will be the author in case of getting the copyright. In the case of cinematograph film, the producer will be the author who can take the copyright. In the case of a sound recording, producer. In the case of a photograph, the photographer will take the copyright. He will be the owner of that thing. In the case of computer generated work, the person who causes the work to be created. So these are the different authors in different areas who can take the copyright of their products and services. Term of copyright. For books and other works of art, it is 50 to 70 years after the date of the author. The laws of different countries vary. I had told this law for the Indian government. In India, for photographic work, 25 years from making the work. For cinematic works, 50 years after making the work available to the public. These are the different terms in case of copyright. These are the differences which I have used to make this lecture. I have used 4 different textbooks, 3 websites and 3 journal papers to make this lecture. Thank you and Jai Hind to all of you.